Hello everyone, this is Crypto BitLaw here with another blockchain legal brief, and today we're going to discuss how Ripple Labs recently claimed a quote very big win in their case against the SEC. But before we dive in, please, if you enjoy this content, hit that like button and subscribe to our channel. We'd appreciate that. And with that said, let's jump right on in and unearth what this big win is all about. Alright, so here we can see Cointelegraph reports that Ripple claims a quote very big win in the SEC case. Ripple Labs was able to gain a victory against the SEC in its ongoing securities fraud case. The judge in the case denied the SEC's motion to review certain documents that may not be material to the prosecution. They say, Ripple Labs has struck a blow against the Securities and Exchange Commission, the SEC's case, after the presiding judge made a ruling that one Ripple community lawyer calls a quote very big win for Ripple. The SEC filed suit in 2020 against Ripple and executives Brad Garlinghouse and Christian Larsen for selling unregistered securities. Presiding Judge Sarah Netburn denied the SEC's request to reconsider shielding documents under privilege related to a June 2018 speech made by the SEC's then director, William Hinman. In the speech, Hinman said Bitcoin and Ether are not securities. The SEC previously did not object to those documents falling outside deliberative process privilege, or DPP protection, as it suggested they only concerned Hinman's personal views and not SEC policies. The DPP exempts some documents in a case from being disclosed by the government so it can confidently review existing policy based on the materials of the documents. The SEC subsequently changed tack to argue the speech reflected Ripple's policies rather than Hinman's personal views and should be shielded. Judge Netburn said the SEC should not contradict itself in trying to flip-flop on its assertions. In her decision, she wrote, quote, "The SEC seeks to have it both ways, but the speech was either intended to reflect agency policy or it was not. Having insisted that it reflected Hinman's personal views, the SEC cannot now reject its own position." In summing up the critical aspects of Judge Netburn's rejection to reconsider, a Ripple community defense lawyer with an extensive case file of financial and SEC cases, James K. Phelan, tweeted today, quote, "The SEC seeks to have it both ways, but the speech was either intended to reflect the agency's policies or it's not." So that's just a recollection of that point that we just noted about the judge in her ruling on this issue. And then this lawyer, Phelan, he stated in his tweet that this was a very big win for Ripple. Continuing on, another Ripple community lawyer and co-founder of Crypto Law also tweeted today to his 191,000 followers that the SEC is now in a hurt locker following Judge Netburn's ruling. He stated, quote, "This is not just a win for Ripple and XRP holders, but for the judicial system. After the March 2021 hearing, I said we were lucky to get Judge Netburn. Some of you disagree, but I still believe it. The SEC is now officially in a hurt locker." Despite the seemingly important ruling, the case isn't winding up yet, and the SEC now has 2 weeks to appeal the decision. Much of the crypto industry is fixated on the proceedings of this case, as the outcome could spell out the future of SEC filings against crypto companies for sale of unregistered securities. A Ripple victory could see the SEC pull back from its aggressive litigations against the crypto industry. However, if the SEC wins, the floodgates could open and lawyers familiar with crypto will have a cottage industry ready-made for them. Now, turning to another article from CryptoNews.com, this article is entitled "Lukewarm Reaction from XRP as Ripple Claims Another Big Win Against the U.S. SEC." And I guess the first point is that the price of XRP, the coin associated with the American fintech firm Ripple, rose modestly after the news of what one lawyer called a very big win for Ripple. So there was a little bit of rise in the price action, but nothing really to write home about. But some of the more important points are here that the SEC was allowed to redact meeting notes. And it states that Phelan's comments about Ripple's big win came shortly after he had shared with his followers that the court had granted a motion by the SEC to redact notes of meetings between SEC employees and representatives of other third parties in relation to the Ripple case. So the fact that the SEC was granted a motion with the court to redact notes of their meetings, I guess what they would consider work product and part of their privileged information, with employees and representatives of other third parties related to this case, that would be a win for the SEC. So we didn't really hear too much about this, but as I'll touch on later, this is all part of the back and the forth of this litigation and how it's actually playing out before this case would come to trial. A lot of this discovery-related litigation and motion practice that plays out in the trenches of a case before you actually go to a trial or a settlement. Continuing on, they say the news was met with anger about this motion to redact. The news was met with anger from many members of the XRP community, with one user saying that it's, quote, no surprise considering that they don't want to make the government look bad, and another claiming that the judges are working for the SEC, which, I mean, that's nonsense and hogwash. I mean, the judges, anytime you lose a ruling, I mean, I wouldn't automatically assume that the judges are working with the SEC or that they're in cahoots. I mean, based on my experience, you know, judges give it then take it away. I mean, you win some, you lose some. This is just the way that the cards fall based on the facts and the applicable law in any given particular matter. Continuing on noting about the SEC's conflict of interest, the news of the court's decision comes after a whistleblower group known as Empower Oversight released documents last Friday that the group said shed light on potential conflicts of interest among SEC officials. According to the documents obtained by the group, the conflicts of interest specifically relate to Ethereum and the question of whether ETH is a security or not. The issue is central to the ongoing court case between Ripple and the SEC, with Ripple arguing that XRP cannot be considered a security if ETH is not considered to be one. Now, that point that we just touched on about XRP not being considered a security if ETH wasn't considered one kind of it hints at the cornerstone of this ruling that just came out, with the ruling in favor of Ripple regarding the shielding of the Hinman speech, discussing whether or not Bitcoin and Ethereum were securities. I think that a lot of people are trying to lump all three of these tokens or coins or digital assets, what have you, Ethereum, XRP, and Bitcoin into the same basket of fungibility. And by fungibility, I mean each one is exchangeable, on a one-for-one basis with each other. So, to give you an example or an analogy, apples are fungible with apples. An apple is an apple, but apples are not fungible with oranges. An orange is not an apple, right? And so in order to really understand the differences between these three tokens or coins, XRP, Ether, and Bitcoin, I think a lot of the understanding about whether or not they're a security strikes to the heart of the core implementation, purpose, design, and release of these tokens. And just because we're going to treat one thing, for example, Bitcoin one way and say that it's not a security doesn't necessarily mean that another crypto isn't a security, because that crypto may have been launched in a different manner. It may have a different purpose. It may have a different creation process, and all of these things kind of touch on issues related to the Howey test that determines whether or not a particular investment is a security or not. And so I think that the reaction here is a little. I think it might be a little bit of an overreaction. Certainly, it is a win for Ripple, and I do believe that the SEC is trying hard to shield this information that was ultimately unshielded, because they may believe there could be a smoking gun there. But it's also worthwhile to consider that just because the government has unlimited resources practically, I mean, they're going to fight every aspect of this case tooth and nail in an effort to try to wear down the other side and win this battle of attrition, right? And if you can wear down the other side and you just kind of fight about every little nitpicking detail, just because you can, you'll ultimately wear down the other side, or at least, kind of break them down a bit to the point where they're not, as emboldened to continue fighting and putting their best foot forward. Ultimately, I said before and I'll say again, I really truly believe that this case is going to end in a settlement before it goes to trial. We could see wins going back and forth. You know, the SEC just got a win with redacting some of the meeting notes that they've had. Ripple just got a win by getting this information related to the Hinman speech unshielded, and it's this kind of back and forth dance in the trenches as this discovery battle is playing out, as this motion practice is playing out, ultimately each side trying to gain more and more leverage through discovery, unearthing more and more information that could be damaging to the other side's case, and then ultimately deciding, okay, at what point does one side or another have enough leverage to eke out the settlement, and then based on how much leverage one side has over another will dictate the terms of that settlement. Or who knows, everyone could be wrong here and we could just go to trial, but I highly, highly, highly doubt that that's going to be the case. But this was just another interesting development in this case. I just kind of wanted to keep you guys posted as to what's going on here. And certainly we're going to keep you guys updated as this case continues to develop. But ultimately, I think it's good to see the judge being neutral in this case and issuing what I would consider, neutral rulings based in fact. Because, I think she was right. Ripple wanted, or the SEC wanted to have it both ways. They wanted to say, hey, this is just Hinman's personal opinion, doesn't reflect the SEC, but at the same time, because it's the SEC's business, it's privileged and you can't have access to it. And the judge just wasn't buying that. And as to whether or not it's going to be truly damning to the case for the SEC, only time will tell. But, there probably is a reason they wanted to shield it, so I guess we're all just speculating here, but this is the information we have to go on, so this is what we're going to discuss and report about. But with that said, I hope you guys enjoyed this content. Please, if you did, hit that like and subscribe button. We'd really appreciate that. And we'll continue to keep you posted as there's new developments in this case. And with that said, thanks again for watching, and we'll see you all in the next video.